My name is Michelle Kerr, a director at MDA Attorneys. We are a South African-based firm specializing in construction and technology law. In February 2023, SAICE released the draft GCC 2023 for comment, with an indication that they hope to release the final version this year. I'll be discussing some of the major changes to Clause 10 of the GCC proposed by SAICE in the upcoming new edition of the contract. Clause 10 of the GCC deals with claims and disputes. The most interesting of the proposed amendments to this clause are the following. Firstly, a new step in the claims process. As it currently stands, unless by the nature and circumstances of the claim, the contractor could not reasonably submit a detailed claim within 28 days, the GCC does not contemplate the two-stage claim process we are familiar with from other standard form contracts, i.e. a notice of intention to claim followed by a detailed. A detailed claim is due within 28 days after the event occurred. In the proposed changes to the GCC, however, a notice of intention to claim is delivered within 28 days of the event, and a detailed claim is submitted within 28 days after this notice, and this will double the time available to the contractor to prepare it. The new version also gives the employer's agent the power to extend the periods for submission of a notice or detailed claim, delaying the effect of the time bar, a power reinforced by the insertion of a new clause under Clause 5. And interestingly, while considering time bars, consideration will also need to be given to a new interpretation clause, which has been inserted under Clause 1.2. The new clause stipulates that a written communication sent by email is considered duly delivered 1 day after it enters the recipient's domain, and this could have serious consequences for notices and claims being delivered by email on the final day of the 28-day period. Secondly, a new step in the process of obtaining the employer's agent's ruling. In terms of the Clause 10 process, once the contractor has submitted its fully detailed or final claim, the employer's agent is required to provide a ruling on it within 28 days. On the new version, where the employer's agent believes that the contractor has failed to give the notice of intention to claim timeously, they must give notice of this within 7 days with reasons. If they don't, the notice is considered to be a valid one. If they do, and the contractor disputes this notice, the contractor must deliver a dissatisfaction claim on this issue. Regardless of whether the employer's agent notifies of failure to deliver the notice of intention to claim timeously, the employer must deliver a dissatisfaction claim on the issue, which must be delivered within 28 days of the cause of dissatisfaction being identified. The current form in which this proposed clause appears has some interesting implications. The obvious one is that the employer's agent has 7 days and the employer has 28 days to raise the time bar issue, failing which they will themselves be time barred from doing so. Something else to be considered is whether, followed to its logical conclusion, this new clause will result in multiple processes, the contractor's claim and a separate dissatisfaction claim delivered by either the contractor or the employer, relating to the same event running in parallel to each other and potentially being referred to separate adjudication proceedings. Thirdly, there have been changes to the subsequent dispute process. On the old version of the GCC, a dispute arises from a rejected claim. There, however, is no deemed rejection of a claim should the employer's agent simply not provide their ruling timeously. On the new version, the employer's agent is deemed to have rejected the contractor's claim if they do not deliver their ruling timeously, and a dispute will arise from an employer's agent's ruling or failure to give a ruling. The new version also proposes amendments to the amicable settlement process. The process is now triggered by delivery of the dispute notice, rather than simply entered into at any time, and is expressly stated to suspend the commencement of adjudication proceedings, which is also subject to a time bar. Concerningly, the clause stating that the amicable settlement proceedings may not be referenced in any subsequent adjudication, arbitration, or court proceedings has been deleted, and the parties will need to exercise additional caution in agreeing the terms of the amicable settlement process they are engaging in. These changes will not, of course, deprive the parties of their right to settle any dispute at any time up until receipt of a final determination of the matter by an arbitrator or a judge. The new version makes a number of small changes, firming up the adjudication process and attempting to fill the gaps which could be left by an inadequately completed contract data. This version also includes a stipulation that the adjudicator's decision must be implemented within 28 days of the date of publication, unless otherwise directed by the adjudicator, firming up the enforceability of this award should the adjudicator fail to do so. Another interesting addition is the provision that where a party has failed to comply with the adjudicator's decision, they waive their right to dispute the adjudicator's decision and refer the dispute to arbitration or court proceedings until such time as they have complied with it.